May it please the court, I, Maxwell Steinberg, and my co-counsel, Kevin Bisley, are representing petitioners, Students for Fair Admission, or SFFA. We welcome your questions.
Thank you. Does the Equal Protection Clause of the 14th Amendment prohibit race-conscious affirmative action?
Thank you, Your Honor. I'd like to begin my answer by illuminating for the court how affirmative action policies operate as racial discrimination in the first place. Even in a holistic admissions process, where many factors are considered, race can still be determinative, which is borne out in the record. According to UNC's own expert, race explains 5.1% of out-of-state admissions decisions and 1.2% of in-state decisions. Consider college admissions like a competitive race. Even if all sorts of factors matter, whether they be conditioning, height, weight, or anything else, giving one runner a 5-meter advantage necessarily puts all of the other runners at a disadvantage. Affirmative action works in much the same way. So yes, since affirmative action policies operate as racial discrimination in both theory and practice, they run afoul to the Equal Protection Clause of the 14th Amendment, which states that never shall any state deny to any person within its jurisdiction the equal protection of the laws. The meaning of this text is clearly borne out in the historical record. For example, Joseph Worcester's 1860 dictionary makes clear that equal protection describes treatment under the law of the same extent, measure, or degree when compared. Since affirmative action programs are inconsistent with the text and historical understanding of the 14th Amendment, this court should follow Brown's promise of allowing no place whatsoever for racial distinctions in public education.
How does legislation enacted by Congress in the 1860s and 1870s affect your answer to question number one?
Well, Your Honor, congressional legislation in the 1860s and 1870s regarding race supports our conclusion that state affirmative action is not permissible. So I'll look at the Freedmen's Bureau and Civil Rights Act briefly, as these are the most important legislation enacted in the era regarding race. Beginning with the Freedmen's Bureau, after slavery, freedmen and other refugees lived in abject poverty, very poor living standards, and they were economically oppressed in a multitude of ways. The Freedmen's Bureau gave aid and physical protection to, quote, destitute and suffering refugees and freedmen and their wives and children, end quote. And this is from the act enabling the Freedmen's Bureau. So no racial distinctions were made in the administration of benefits, and this is coming from the statute itself. Benefits were given out on a need-based system, not a race-based system. Further, they were humanitarian in nature, and this indicates that the framers and the legislators of this Freedmen's Bureau Act were attempting to remedy poverty and hardship. They were not trying to create a racial preference. So now let's look at the Civil Rights Act of 1866. In addition to poor economic opportunity, freedmen, of course, faced racial discrimination and legal oppression from black codes and from Jim Crow laws. This act expressly granted full and equal benefit of all laws and proceedings for the security of person and property, as is enjoyed by white citizens, to persons of every race and color. And this is quoting from the text of the Civil Rights Act. The Act's mention of white citizens does not impose racial classifications. Rather, it strikes down such classifications by granting equal protection and treatment under the law. The 14th Amendment parallels much of the language and the meaning of the Civil Rights Act. Therefore, the 14th Amendment does not allow for racial classifications either. Considering the legislation passed by Congress in the 1860s and 1870s, it is clear that racial preferences were not established, they were prohibited. Lastly, according to Representative John Bingham, one of the principal framers of the 14th Amendment, quote, the law in every state should be just. It should be no respecter of persons. The 14th Amendment was written to constitutionally prohibit state discrimination, as Bingham indicated. This includes affirmative action.
Let's assume that the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument still work more than 150 years later in a very different society?
The framers of the 14th Amendment drew no such conclusion. Indeed, the historical record bears out the exact opposite, as my co-counsel just explained in detail. We submit powerful evidence to this court that legislation of the time, specifically the establishment of the Freedmen's Bureau and the passage of the Civil Rights Act of 1866, were fundamentally race neutral, consistent with the 14th Amendment's equal protection guarantee. If the court does not agree with us on that point, however, it's fair to classify these actions as purely remedial. The function of the Freedmen's Bureau was purely remedial, designed not to establish a system of racial preferences, but instead to guard against discrimination itself, and provide humanitarian aid to those in dire circumstances because of an organized system of de jure oppression present for generations prior to the 1860s and 1870s in this country. The Civil Rights Act of 1866, by the same token, attempted to rectify a system of slavery that had been occurring in this country for generations. Universities currently do not rely on this same remedial interest. Why? Because they can't. Those remedial interests could be justified in the 1860s and the 1870s, immediately after the end of slavery. Now, we are no longer talking about former slaves. We are talking about generations later, if that, because of course, affirmative action policies apply a preference to more than just Black Americans, as we all know.
Let's assume that the framers of the 14th Amendment thought that people of African descent deserve certain race-conscious privileges due to the unique context of slavery. Would the framers have argued that members of other races, such as Hispanics, Asians, and Native Americans, could receive similar privileges?
So, Your Honor, I'd like to begin with a clarification on the possibility of preferences for African Americans. The framers of the amendment would not have seen fit to extend benefits to any persons of African extent just categorically. Former slaves had suffered uniquely under slavery. Logically, the framers would have thought privileges especially necessary for those who had suffered from slavery. Now, of course, Congress did work significantly towards aiding Blacks regardless of the condition of servitude. And this was based on overcoming legal oppression, Black codes, and other forms of de jure discrimination in state law. Continuing with Hispanics, Asians, and Native Americans, the framers of the amendment would not have argued that they could receive these preferences. These groups were never the primary subjects of slavery or its consequences, and there was no reason that the framers, assuming they would have deemed benefits for freedmen necessary, would argue that any other racial minority also deserved the benefit. Lastly, as my co-counsel has explained, there are no living persons who are once enslaved today. Therefore, no one has suffered from the unique context of slavery, and the framers of the 14th Amendment would not have argued that anyone today deserves racial preferences, even if they deemed these preferences necessary to rectify the errors of slavery.
What would the framers of the 14th Amendment have thought about affirmative action policies that benefit people on the basis of sexual orientation or gender identity?
So I want to begin in my answer to that question by recognizing that whether the framers of the 14th Amendment thought the amendment to ban just racial discrimination or discrimination based on any other categories has been a continuous debate among legal scholars and justices of this court. It's clear, though, that eliminating racial classifications was the framers' primary goal in drafting the 14th Amendment, and this understanding is consistent with how the court has clarified tiers of scrutiny for different classifications. This court has never held that distinctions on the basis of sexual orientation or gender identity are subject to strict scrutiny as racial discrimination is. Given the history of racial discrimination in this country, this court's line of precedence makes clear that racial discrimination is unique. For example, this court's landmark decision in Loving proclaimed that racial classifications, and I'm quoting from the opinion, are odious to a free people whose institutions are founded upon the doctrine of equality. Accordingly, given the different standards of scrutiny, the disposition of this case in SFA's favor does not necessarily mean that this court would have to hold that these other preferences are unconstitutional. So the court does not need to delve into that question in the disposition of this case and open that can of worms.
Does Brown v. Board of Education prohibit race-conscious affirmative action? In your answer, please address Bakke and Grutter.
So I'd like to just begin by stating Brown versus Board prohibits racial affirmative action in education. Southern schools had long been segregated on the basis of race, and this gave unequal opportunities for education. The use of race in public education in Brown was decisively consigned no place under the Constitution. And as the case affirmed, quote, no state has any authority under the Equal Protection Clause of the 14th Amendment to use race as a factor in affording educational opportunities. This is from the oral argument in Brown. Brown found it impermissible to use race when assigning students to schools. It is completely abhorrent to the ruling in Brown to permit states to admit or deny students on the basis of race. Now I'll touch on Bakke and Grutter briefly. So Bakke correctly found that racial preferences demand strict scrutiny, but it incorrectly allowed a holistic consideration of race that does not follow the precedent of Brown. Quoting from Bakke itself, preferring members of any one group for no reason other than race or ethnic origin is discrimination for its own sake. This the Constitution forbids. Although holistic racial consideration was permitted in Bakke, the case ignores that even a holistic admissions process must necessarily involve granting some racial preference for no reason other than race or ethnic origin. Grutter similarly permitted holistic racial classifications in order to reach a critical mass in a similar manner as Bakke. It incorrectly held that the critical mass functions as a quota, Grutter incorrectly held that the critical mass of minorities does not function as a quota, even though seeking for a certain quantity of minorities is undeniably such a quota. And lastly, it found that giving preferences for checking a racial box is permissible, even though this is clearly not narrowly tailored in any way. So Brown unambiguously prohibits racial affirmative action, even though Grutter and Bakke ignore its commands. Under the precedent set by Brown, racial affirmative action was never permissible, and it must come to an end.
In 2003, Grutter observed that, quote, 25 years after this case, the use of racial preferences will no longer be necessary to further the interest approved today, unquote. Will there ever be a point in time in which racial preferences are no longer needed? If not, should the court allow racial preferences to go on forever?
To answer your first question, Your Honor, that point in time has been reached today. And to answer your second question, Your Honor, the answer is absolutely not, which I'll explain in detail in a moment. Grutter recognized that the test of the success of university affirmative action policies would be, as Sandra Day O'Connor in her majority opinion explained, their efficacy in eliminating the need for any racial or ethnic preferences at all. That there is still more work to be done in furthering racial equality in this country is not a sign that universities need more time, but instead a glaring indication that Grutter failed at its central mission. The way that universities defend affirmative action policies, with expiration dates that are based on parameters as subjective as cross-racial understanding and feelings of racial isolation on campus, mean that nobody can ever be sure that affirmative action policies will ever come to an end. This is wholly inconsistent with the Grutter majority's cautioning that a termination point for affirmative action policies is necessary to assure all citizens, and I'm quoting from the opinion, that the deviation from the norm of equal treatment of all racial and ethnic groups is a temporary matter, a measure taken in the service of the goal of equality itself. If the court is unwilling to hold UNC's scheme illegal in this case, especially given that UNC has rejected every race-neutral alternative conceived of as failing to meet its current actual level of diversity, it will only serve to entrench these types of racial discriminatory programs forever and ever, and the stereotypes that come with them as baggage forever and ever. For another few decades before this court will be forced to reconcile this question again.
Should Grutter v. Bollinger be overruled? Please address the Supreme Court's recent discussion of stare decisis in Dobbs v. Jackson Women's Health Organization.
Grutter must be overruled, Your Honor. It does not fit the criteria to be upheld under stare decisis. The Dobbs majority overruled Roe notwithstanding stare decisis for several reasons. First, Roe is a grievously wrong misinterpretation of the 14th Amendment, and it had no basis in the Constitution itself. Second, Roe was never accepted by the general public, and it sparked significant debate and controversy, only inflaming the national abortion debate. Third, the frameworks of Roe and Casey were fundamentally unworkable. And lastly, there were no reliance interests to justify the affirmation of Roe. Grutter versus Bollinger meets the same criteria. It was grievously wrong in its interpretation of the 14th Amendment, and it has no constitutional basis, as my co-counsel and I have laid out. Further, Grutter has not been widely accepted. It has caused significant harm to many college students, and it has similarly inflamed the national debate on affirmative action. Grutter is fundamentally unworkable, as universities cannot even identify when they reach a critical mass of minority students. And that makes adjudication here nearly impossible. And lastly, Grutter has no reliance interests. It even advocates for its own reversal by 2028, further undermining the claim for a reliance interest. Your Honor, as is consistent with this court's treatment of stare decisis, Grutter versus Bollinger cannot be upheld.
If the court declines to overrule Grutter, can the plaintiffs prevail?
Even under Grutter, UNC's admissions policy fails strict scrutiny because the university has workable race-neutral alternatives which it rejects. UNC must prove unequivocally that the alternative plans SFFA proposes do not promote the interests this court has recognized in affirmative action policies, the educational benefits of diversity. They fail in proving this burden. We have 3 race-neutral alternatives that I'll note: Simulation 3, Simulation 8, and Simulation 13, which are discussed in our brief. And they're also described in detail in the record. Let me clarify to the court. SFFA's models are workable because they use a data set of over 162,000 real UNC applicants who receive UNC's holistic ratings. The district court rejected SFFA's proposed race-neutral alternatives because they would alter UNC's class in a small way. But the idea that a race-neutral alternative is unworkable because it may not achieve the same levels of racial diversity in the status quo when the race-conscious plan is occurring cannot be correct. If it were to be, it would reinforce a quota, being whatever the racial diversity levels are in the status quo, which Bakke squarely forbids. Maintaining a holistic admissions process is not an end in itself. If it were, this would not be narrowly tailored to pass strict scrutiny. And the fact that the district court approved of UNC's plan, despite the race-neutral alternatives we propose, in deference to UNC's exact current levels of diversity, is reason enough to show that the strict scrutiny regime Grutter endorsed, which ought to be demanding to protect against the dangers of racial discrimination, has proven unworkable in the lower courts. This is reason enough to overrule Grutter and hold that racial affirmative action is wholly inconsistent with the 14th Amendment.
If the court overrules Grutter, will the military have difficulty recruiting a diverse armed service?
Your Honor, the military will not have any difficulty recruiting a diverse armed service if this court decides to overrule Grutter. So the military can recruit a diverse armed service without even granting any racial preferences in the first place. Before the Coast Guard began to implement affirmative action in its academy admissions, it used different recruiting techniques to encourage minorities to apply. Without any racial preferences at all, the Coast Guard Academy had reached virtually identical levels of diversity compared to those military academies who are using preferences. There's no reason today's military cannot replicate this and have a diverse officer corps without any distinctions on race. Furthermore, the military is able to select officers from its enlisted service members rather than constraining itself to academies and ROTC. This would provide more opportunities for minorities to become officers, and this would not utilize any affirmative action. And the government may have different interests in the military context, of course. Now, if the military would have difficulty recruiting a diverse service or officer corps, this is irrelevant to the court's consideration of Grutter. Regardless of the possible impacts, this court must get the law right and end racial affirmative action. Accordingly, we ask this court to overrule Grutter v. Bollinger and reverse the decisions below.
Thank you.
Thank you.